Good afternoon. We are continuing this session of oral arguments at the North Carolina Court of Appeals. And we are conducting the oral arguments this afternoon virtually by order of the court because of some COVID exposure in the court family. My name is Lucy Inman, and I am presiding today with two of my colleagues, Judge Valerie Zachary and Judge Darren Jackson. And next on our docket for oral argument is R.E.M. Construction, Inc. versus Cleveland Construction, Inc. et al. Court of Appeals docket number 21-781 from Buncombe County. Counsel, are you ready to proceed?
Yes, Your Honor.
Very well. We'll hear you now.
Good afternoon, Your Honors, and may it please the court. I am Seth Price, and I'm one of the attorneys for the appellant Cleveland Construction. Not sure where she is on your screen, but immediately to the right of my image on my screen is my co-counsel, Carmela Mastriani of the Hamilton Stevens firm in Charlotte.
Welcome, Ms. Mastriani.
I want to start out with what I think is a very obvious proposition, and that is that arbitration awards are rarely vacated. That's both under the North Carolina Act and under the Federal Act. It is very unusual to vacate awards, though there are a fair number of cases where folks have come in before the Court of Appeals and have tried to get them vacated. There are very, very limited grounds for vacating arbitration awards. So, for example, an error of fact or a series of fact errors is not going to lead by an arbitrator, is not going to have the result of an award being vacated. And the same is true regarding legal issues. Errors of law, parties have bought into errors of fact and errors of law when they agree to the arbitration process. That's one of the things parties agree to when they arbitrate. And so parties that go to arbitration, that elect arbitration, should understand that they're giving up certain things. And one of the things is to appeal those sorts of errors. And I think most parties that go to arbitration know that. And if they don't, sort of shame on them, they should. But they are not giving up all rights. And there are limits to the finality of arbitration awards. And this case implicates one of those limits, because under both the North Carolina Act and under the Federal Act, where an arbitrator exceeds the powers, that's the term used, where an arbitrator exceeds the powers of the arbitrator, an award may be vacated. And in North Carolina, as I said, there's actually a fairly, I don't want to use the word, I don't want to sort of oversell, but there is a body of cases over an extended period of time where courts have tried to construe the concept of what is exceeding powers. And that's been briefed all over the place by all the parties in this case. And I thought for purposes of oral argument, I was going to focus on 4 cases spanning 1987 to 2018. I chose those because it's a 30-year period, it's relatively recent, and I'm not sure that there's any new ground. There's not anything aha moments in any of them, other than I saw there was one case that went back to the 1890s. I just thought it was better to use a more recent. The case I'm going to start with is the Fison case. And the reason I start
Excuse me, but before you start on that, I just have a couple quick questions.
Yes, Your Honor.
First of all, is there an arbitration agreement separate from the subcontracts?
The arbitration agreement is contained within the subcontracts.
Okay, I just wanted to make sure of that. And is there a provision in the subcontracts that precludes the panel's award in this case?
The way you have phrased it, not the entirety of the award, Judge Zachary, and we don't seek to vacate the entirety of the award. We seek not to vacate the finding on liability, not to vacate the finding on the reallocation of the AAA expenses. We seek to vacate only that portion where they awarded damages contrary to the express terms of the agreement.
Mhm.
Does that answer your question?
Well, what I was wondering is what provision do you rely on to say that the damages award was precluded by the
Okay.
subcontracts?
So if you look at Article 31.8, which is at record page 36, and your honors, I'll tell you, as is the case in oral argument, sometimes you go out of turn. So I'm going to share, hopefully I'm about to share something that'll keep everybody from having to flip through. That's incredibly small on my copy. Is that popping up a page that says 138 at the top? Excuse me, a page that says record 136 to 138?
Yes, I see page 138, and congratulations on your technological acumen.
And it's not tiny. It's not tiny on my screen.
Okay, so let's try this. I'm gonna answer your question, Your Honor, by referring back to the panel's findings, and it's really at the heart of what we contest. The panel initially found that Cleveland, Cleveland fired R.E.M. Said you're in default. R.E.M. said no, we're not. So Cleveland said you need to pay us the excess cost of completing your work. R.E.M. said you need to pay us to the extent you hadn't paid us at termination. The arbitrators ruled against Cleveland on the liability issue, finding that the termination was improper. Cleveland had default terminated R.E.M., and R.E.M. Said no. The contract says that when there is a wrongful default termination, it's converted to what's called a termination for convenience. And using, I'm going to go through these four provisions. So what the panel did, this is sort of paragraph 67, page 136 of the record. This is the end of the panel's liability discussion. And they say the panel determines Cleveland did not properly terminate for default, and determines that under 31.8 of the subcontracts, the termination is deemed to be for the convenience of Cleveland. That's sort of what I would call the liability component of a contract breach. And then they say we're going to address the damages. R.E.M. shall be entitled to monetary compensation from Cleveland in accordance with Article 31. For purposes of responding, Judge Zachary, to your question, I think the next provision is this damages award. Because now as I said, Cleveland doesn't contest the liability award. Cleveland doesn't contest that portion of the liability award where the arbitrators reallocated arbitrator fees. Paragraph 73 is nothing more than the panel's direct quoting of what's in Article 31.8 of the subcontract. And just for record purposes, Article 31.8 is at record page 36, but the panel quotes it in its entirety here. So here's what they say. They track the contract. They say if after termination, it is determined for any reason sub was not in default, well, they've already said sub wasn't in default, or that sub is not properly terminated, then the termination shall be deemed for the convenience of Cleveland. They've already in paragraph 67 said that's where they're going. And then they just start discussing damages. And they say what sub's damages are in the case of what I'll call a wrongful termination. And they say the sub shall be entitled to what they refer to as actual direct cost of the subcontract work. This is paragraph 73. They then go on, subcontract work, materials, no overhead, no profit, no compensation for work not performed, no special damages. It's a roadmap. But more than that, and this is in accordance with the cases, it's a limitation. The cases talk about the contracts limiting the scope of what the arbitrators can do. And this particular contract specifically says actual direct costs.
So
Next
is it your contention then that Article 31 negates the incorporation of the AAA rules?
I think it puts an end to the inquiry about that specific Article 48, but I will answer your question by saying Article 48 of the AAA rules has two parts to it. The first part says that the arbitrators can award a remedy that they think is fair. And remedy is not a defined term, but they already under the contract have a remedy, damages. So if remedy means anything, it must mean something other than damages. So for example, a subcontractor says, hey, I left my wheelbarrow there. I want that back also in addition to damages. That would be a different remedy. But the remedy in this case is damages. So to the extent, and I'll jump down to it, Article 48, that's right there, says they may grant remedy or relief that they deem just and equitable. The remedy is damages. It's not a right to ignore this. Second part, Your Honor, is the following. Even if they deem it to be just and equitable, it has to be within the scope of the agreement of the parties. What's happened here is the scope of the agreement of the parties limits R.E.M's recovery to actual direct cost. So even if they get past the first part, which is ignoring the contract is something arbitrators can do because anytime parties choose Article 48, they're giving up the contract. Don't concede that. But even if they get past that, it still has to be within the scope of the agreement. And the reason this is not within the scope of the agreement is spelled out by the arbitrators. They say R.E.M. gets actual direct cost, quoting from the contract. That's all they get. They don't get overhead. They don't get profit. They don't, all the things they don't get. They only get actual direct cost. And then they immediately in the next paragraph, paragraph 74, say the contractual starting point for determining the damages. Contractual starting point, Your Honor. They get it. Is the actual direct cost. And then they say there is no evidence. And Your Honor, Your Honors, they don't say there's a scintilla of evidence. They don't say, well, we wish there was more. But they say, R.E.M., you had the burden of proof on damages. The contract required actual direct cost, and you didn't put on that evidence.
Well, what it actually says is the contractual starting point.
Absolutely.
That's starting point. And so does the agreement prescribe or proscribe any method of determining damages? When it says a contractual starting point for determining damages?
Sure, because in 31.8, it says what the sub gets, actual direct cost. They get that. So when they say the starting point is, this is the provision that controls. And then they go on and say, but there's no evidence. There's no one would contend, and no one has contended, that there's any other contractual provision that they can travel under. The panel, Your Honor, the panel got it. They understood. They then said, there is none. And my spin on it, of course, I'm an advocate, is they said, it's unfair to deny compensation to R.E.M. even though they didn't meet their contractual burden to put on evidence of actual direct cost. And then they jump to this Article 48, ignoring the within the scope of the agreement part.
Is there a provision that provides that they have to, that's the R.E.M.'s burden to provide the evidence of the amount of actual direct cost?
The burden of proof would be, as a matter of law, on the party putting on the damages evidence. It has to, I can't put on their evidence for them. They're the
Well,
only one.
in fact, you can, can't you? I mean, if
I
you,
could
if you
put-
put on evidence and the court or the arbitrators find that, that that's sufficient to prove their case.
Sure, but that didn't happen. And that's, see, Your Honor, the thing here is the panel, what makes this particular award, what I think is more egregious than the FCR case, which is one of the cases I was going to talk about, and which, what makes this more egregious is they walked through the process. They said, this is what happens in the event of a wrongful termination. He gets actual direct cost. And I would say that whether it was my burden to put on his evidence or put on competing evidence, nobody put on any evidence. So there was no record, not even a scintilla, Your Honor. There was nothing there. That's what they said, no evidence. And then they jumped to Rule 48 and ignored the within the scope of the agreement part. No party, because it's not there, has suggested that there's any provision within the subcontract other than 31.8 that would control the damages award. And to be clear again, Your Honor, I want to be totally clear on this, which is it's a contract case. We're not happy. Cleveland wasn't happy with the award on liability. They thought the panel got it wrong, but at most it's a mistake. They weren't happy with the reallocation, but at most it's a mistake. But on this, they tracked the contract. They started on 67 and they said, under these circumstances, Cleveland didn't properly terminate. 31.8 controls, and this may answer your question more directly. R.E.M. is entitled to compensation per Article 31. Then they quote Article 31. They say, here's what's in Article 31. Sub shall be entitled to actual direct cost. Contractual starting point is actual direct cost. No evidence. Nobody put on the evidence, whether it was Cleveland's burden or their burden. There's no evidence whatsoever of actual direct cost.
Well, I have one more question, and then I'll
Yes.
try to let you get back to what you had planned to say. If manifest disregard is synonymous with exceeding authority, then why should we adopt the manifest disregard test?
You don't need to, Your Honors. You can simply find that they exceeded power. I would answer your question like this. I believe it's the Fourth Circuit has discussed manifest disregard and whether or not it's still a basis. It's not clear to me that a North Carolina state court has weighed in on this. I think ultimately the test for manifest disregard and exceeding powers is pretty much the same, but the statutory basis contained in the State Act at 1-569-23A4 is clearly the exceed powers. And the four cases, I think, sort of, for me at least, and I would suggest for the panel, trying to interpret when, in fact, an arbitrator exceeds powers, I would say when they make a mistake, they don't. But when they knowingly disregard the contract, they do. And this panel, what this panel did was they said there's no evidence, having cited the relevant contractual provision, they then say no evidence. So one of the things about sharing the screen, Your Honor, that's different from being in court is I lost the view. I see I have about 6 minutes left, having now scrolled through, and now I got the clock there.
You can, I don't know how to do it for you, but you can unshare.
I was gonna if Judge Zachary, if I've addressed your questions, then I'm gonna stop sharing. So I'm gonna stop for now on the sharing. What I wanted to say about the four cases was the Fison case is I think it's a great case for illustrative purposes. It sort of is a history. It cites to a lot of the prior cases. It's from 2007. And there they upheld an arbitration award because the only limitation was the parties first went to court and then they agreed that instead of going to court on the eve of trial, they agreed to arbitrate all claims. And the arbitrator said that includes interest. Trial court said, well, no, I'm going to knock out the part on interest. And the Court of Appeals said, well, all claims is pretty broad. There's no limit there. And they told the trial court to reinstate the interest award. But the interesting thing about the Fison case is that they quoted to another case that then cited a bunch of other cases. And then this is what the Fison court said that I think is so important to the decision of this case. They said, in the cases where awards are vacated, the arbitrators acted, quote, contrary to the express authority conferred on them by statute, or in our case, and by the language of the parties' private agreement. So, taking out the statute part here, they acted contrary to the express authority conferred on them by the language of the parties' private agreement. And the cases they discussed there primarily were the Wilson case and the FCR case. In the interest of time, I'm going to pass on Wilson, but the FCR case is a 1995 case where the parties had a contract and it allowed for liquidated damages for late completion. But the arbitrator assessed liquidated damages for late start and late completion. Again, the contract limited what the arbitrator can do, and the Court of Appeals said the parties agreed to liquidated damages for late completion, not late start, and they said that part gets tossed. The Barnhill case, which is an unpublished case, and I understand Rule 30 therefore governs the use of that case. The Barnhill case is worth looking at because it's a 2018 case, and I said I was going to cover a 30-year period, and your bookends are the Wilson case, which an arbitration award was vacated because they included attorney's fees that likely violated the statutory rate, and the 2018 Barnhill case. And Barnhill cites the exact language from Fison that I just read to you. It's a direct quote. They say the standard is acted contrary to the express authority conferred by the language of the parties' private agreement. So
And
I would submit.
Barnhill is an unpublished case, right?
Unpublished, absolutely, Your Honor.
What you're saying is you're really relying on the same language from the earlier. Okay.
It's, Your Honor, it's just bookends. Basically, I said I was going to do the 30-year period. And so I have the Wilson case. Barnhill cites back to that Fison language with approval.
Okay.
So I would say that the case law, Cleveland would submit the case law is arbitrators make mistakes, no vacate. Arbitrators understand their limits, know what the contract says, but decide we're not going to follow the contract because it produces a result that we deem to be unfair. And that's precisely what happened here. Federal authority, the Stolt-Nielsen case, the court there interpreting the federal statute had a flowery way. I actually wrote down flowery language as a reminder to myself. They said arbitrators exceed their powers when they stray from interpreting and applying the language of the agreement and dispense their own brand of industrial justice, which conjures up all sorts of interesting stuff. But basically on this project, on this case, reallocation of the liability issue, no. No suggestion by Cleveland that should be vacated. The reallocation, no suggestion by Cleveland it should be vacated. But when arbitrators do what these did, which they said we're gonna give them damages, though they put on no evidence of the contractually required actual direct cost, that is a knowing departure from the contract. And I would suggest to the court that this case is more extreme than any of the other cases that have been vacated, because as the case currently stands, the posture is arbitrators can ignore the contract. That's what this basically says. Parties give up a lot when they go to arbitration. There's no doubt about that. They give up most of their appeal rights. But if arbitrators can ignore contractual limitations because they believe those contractual limitations will yield unfair results, for the party that failed to put the evidence on, and Judge Zachary, in all due respect, sure, Cleveland could have put on evidence for R.E.M., but didn't. R.E.M. failed to put on its own evidence of actual direct cost. It's a very scary case because right now, as it stands, parties are giving up not just their rights to appeal mistakes, but if arbitrators go far astray, they lose.
Mr. Price, can I just ask you a quick question? I know we're getting into your rebuttal time.
Yes, Your Honor.
I just want to make sure we're all on the same page about the standard of review.
So facts clearly erroneous and de novo on the law. And I think this is I think this is a legal issue.
So would interpretation of the agreement itself is de novo review?
Yes, Your Honor.
Okay, thank you.
So I've overstayed my welcome by 30 seconds. So
That's my fault. So thank you.
Thank you, Your Honors.
Thank you.
May it please the court, I'm Fenton Irwin of the Mecklenburg County 26th Judicial Bar, representing R.E.M., the appellee in this case. I would first like to point out that record page 138, paragraph 74, there's a part of the statement in that paragraph that was omitted. That statement reads, in discussing the determining or starting point for determining damages, the sentence reads, the problem is that there is no evidence of actual direct cost of all work, followed by the sentence that says there was little evidence of the job costs of R.E.M. presented to the panel. I want to point out that all costs is not really what we're talking about here. I would like to say also that R.E.M. has elected to resolve this dispute under the contractual provision that allows it to be arbitrated. And in that connection, the arbitrators were elected by the parties, handpicked, selected after much vetting, a long period of time. The arbitration was conducted. The award of the arbitrators was rendered and it was served upon the parties. And then after the arbitration award was rendered, the arbitrators entered, and on pages 143 and 144 of the record, an order on claimant's request for modification of the award. It was prepared and it was signed by each of the three arbitrators. If you read that, you'll see that Cleveland filed a motion under Rule 51A, of the American Arbitration Rules of Construction Industry Arbitration. And that rule under 51A, which is on the record page at 228, allows the arbitrators to correct clerical errors, typographical errors, technical errors, and computation errors. In response to that request under Rule 51A, the arbitrators entered this order. And as a result of the reconsideration, they did make a computational change that appears in the record. But as to the challenge to the award of $236,151 to R.E.M., the arbitrators said that portion of the award was not covered within Rule 51A. And further, the arbitrators clarified their award in that document by saying that R.E.M. performed work and incurred costs up to October 5 of 2018 when it was terminated. They also said that the record showed undisputedly, the last payments that were made to R.E.M. were on September the 11th, 2018 for work that R.E.M. did May, June, and July of 18. They also said that it was clear that Cleveland benefited from the costs that R.E.M. incurred in performing the work from August 1 to August 5 of 18. And then further, they stated, based on the evidence in the record, the panel was within its power pursuant to AAA Rule 48A to award R.E.M. damages of $236,151. This order was entered after Cleveland had made the same argument substantially that it makes to the court today. The arbitrators also said, except as modified, the award of the panel remains in full force and effect. Now, our North Carolina statute allows the arbitrators to clarify the award when a party moves to modify or to correct the award. That statute is NC Gen Stat 1-569.20, subparagraph A. This is what the arbitrators did following the challenge to their own award. They clarified the award, showing that their decision met the requirements of Rule 48A. And basically what they're saying is that Cleveland benefited from the work and the cost of the work by R.E.M. and it didn't pay, and therefore it should be paid. Furthermore, the agreement or the arbitration award is within the agreement because it's fundamental that the work to be done by R.E.M. when done properly is creates a contractual obligation on R.E.M. to pay. And that's exactly what the situation that we have here is. Very elusively, if you will, the footnote number 1 in the order says that Cleveland, this is by the arbitrator's footnote, complains about the panel's reliance on Exhibit P141R. That Cleveland exhibit merely confirmed the obvious on the costs incurred by R.E.M. in August and September, which benefited Cleveland and which Cleveland did not pay to R.E.M. See also Cleveland Exhibit P253. This is Cleveland's evidence of what those costs were as identified in the award by them. To reverse the award of the arbitrators would be unjust in the circumstances of what was exactly found to exist by the arbitrators. The arbitrators found that there were 2 different default notices given between the period of May 23 of 18 to September the 20th of 18. And that these notices of default incorrectly accused R.E.M. of default. But R.E.M. was not in default. That was found at record page 135, paragraph 65. Arbitrators found that there wasn't any default during that period of time. They also said that R.E.M. the allegation was that R.E.M. did not provide sufficient manpower, supervision, and equipment. And they found record, page 134, paragraph 57, that wasn't the case. They withheld, that is, Cleveland withheld payments for June, July, and August, May, June, and July of 2018, and it was not in default during those times. In fact, the arbitrators affirmatively found at record page 133, paragraph 53, that it was Cleveland that was responsible for the delay in progress of construction. They found at record paragraph 135 and 36 that Cleveland actually accelerated the work of R.E.M. without monetary compensation. Record page 133, paragraph 154, record page 133, Cleveland was responsible for the active interference of R.E.M. and in spite of the fact of delay not being caused by R.E.M. and in spite of the failure of Cleveland to compensate R.E.M. for acceleration, in spite of these adverse conditions, R.E.M. continued to work. It did not quit. It kept on. Now, what is actual direct costs of the work? That's a phrase or a clause that's not identified in the contract. Subcontractors, in this particular case, at the beginning of the job, had to submit a schedule of values or an allocation of the work and the value for which it would be paid monthly, and then submit monthly invoices as the work went along based on the work that was complete. That's the way that construction costs are determined. Now, common sense tells you that the actual cost would be what do you pay for labor and material. But what are actual direct costs? If you have a laborer that you're paying $25 an hour to, but in addition to that, you're providing vacation benefits, medical benefits, other similar benefits, automobile, per diem expenses, are those to be included as a part of the direct job costs? It's not defined. It's not clear. How do you prove actual job costs? And if you prove what you spent for labor and material, are those actual job costs? In addition to that, the arbitrators found that Sean Bowman, who was the project manager on the job, asked R.E.M. to do change order work. And it billed, and R.E.M. was told to do the work and bill for the labor, materials, and so forth at the end of the job. The arbitrators determined that because that R.E.M. did not submit any formal change order to Cleveland in accordance with the contract documents, that R.E.M. could not collect for its change order. Now, there's an inconsistency in the provisions that deal with the default termination and the conversion to a termination for convenience. And Lex is going to direct his attention to that. But I will say that Cleveland argues that we can be wrong when we withheld payments for May, June, and July. We can be wrong. We can accuse R.E.M. of delay of its work improperly. We can keep the value of R.E.M.'s change order work because it didn't prepare the formal change order. And we can terminate R.E.M. and not allow them to have anything but their actual direct costs, whatever those cost might be. We have that gives to Cleveland a windfall. If they had not default terminated, they would have paid a different sum to R.E.M. If they had defaulted or had terminated for convenience, they would have paid a different sum. But here, they're able to terminate and they get a windfall because there's no profit and no overhead on the part of, that's collectible on the part of R.E.M. Thank you for listening. I'm going to let Lex Irwin take it from this point. Thank you.
Good afternoon, Lex Irwin for the appellee R.E.M. I'd just like to clarify what my father, Fenton Irwin, was saying is that under Cleveland's argument, they would get this windfall, and it's not just and it's not right. They shouldn't be allowed that result. I'd like to discuss an ambiguity in the contract related to the wrongful termination by Cleveland of R.E.M. that then gets converted under the contract terms. If it's found to be a wrongful termination, it gets converted automatically to one for convenience. And Mr. Price and Cleveland have relied exclusively on section 31.8, which is at record page 36. And there it says, if after termination, it is determined that for any reason subcontractor was not in default or that subcontractor was not properly terminated for default, in such termination shall have been deemed to be for convenience of Cleveland, and subcontractor shall be entitled to the actual direct cost of subcontractor work satisfactorily performed, materials furnished prior to notification of termination. Then says, subcontractor shall not be entitled to compensation for profit and overhead. Subcontractor shall not be entitled to compensation for work not performed or materials not furnished. You need to square that with section 27.1. 27.1 governs termination for convenience. Termination for convenience under section 27.1, which is found at record page 32, specifically says that after termination for convenience, subcontractor shall be entitled to the actual direct costs of all work satisfactorily performed and materials purchased prior to notification of termination. That squares. Then it says subcontractor shall be entitled to compensation for profit on work performed. So in 27.1, it says subcontractor shall be entitled to work for profit on work satisfactorily performed, whereas 31.8 says subcontractor shall not be entitled to compensation for profit and overhead. Those reading those provisions together, how does one square that? How does one square that ambiguity about whether R.E.M. is entitled to profit or not? I think the starting point may be section 31.8, but then you also have to look at 27.1. And as the court knows, any ambiguity is construed against the drafter. It's found in Novacare Orthotics and v. Spielman, 137, NC App 471 from 2000. And in 2000, this court held it is a fundamental rule of contract construction that the courts construe an ambiguous contract in a manner that gives effect to all of its provisions if the court is reasonably able to do so. That was from the Gay v. Sabre Healthcare Group case, 271 NC App 1. That was from 2020. North Carolina Court of Appeals has also held that whenever the court is called on to interpret a contract, its primary purpose is to ascertain the intention of the parties at the moment of its execution. The heart of the contract is the intention of the parties, which is to be ascertained from the expressions used, the subject matter, the end in view, the purpose sought, and the situation of the parties at the time. And so what you need to look at is 27.1, as well as the next page is 29, Article 29. governs claims for damages. And that section says that subcontractors shall not be entitled to anticipated profit on any work not performed, whether arising from the termination of agreement or Cleveland's breach of this agreement. So if you read all of those in context, reading them all together, what it's saying is that the subcontractor should be entitled to the work, to be paid for the work it performed. It's not going to be entitled to lost profit on future work. And so when the arbitrators looked at the payment applications from August and September of 2018, that's exactly what direct costs and profit are, is the payment applications. That's how they determined that R.E.M. was entitled to $236,511. They may have started at 31.8, but the evidence was, what are the payment applications? What were the invoices?
So are you arguing then that the panel didn't need to refer to the AAA rules at all?
No, they were within their rights to refer to the AAA rules because the AAA rules allow them to do what's equitable and just and within the scope of the contracts, which is exactly what they did.
Aren't the AAA rules, since they were incorporated into the contract, aren't they actually part of the contract as well?
That's right. They are.
So, I mean, even though the arbitrators say that they relied on the AAA rules, you think that that this panel should find that they did not find, but should
No.
conclude
They certainly relied on the AAA rules as well as the contract, reading them all together.
Okay. I'm sorry, Judge Inman.
No. I was just trying to follow, and Mr. Irwin, just make sure I'm on the same page. What you're arguing is fundamentally you don't disagree with Mr. Price's argument that the AAA rule says it's got to be within the scope of the contract, but you disagree with his argument about what the contract says because of these additional provisions that he did not mention in his argument. Is that correct?
That's correct.
Okay,
As
thank
well
you.
as actual direct costs. There are multiple ways to prove actual direct costs. There's nothing in the contract that says that a subcontractor must prove every single nail that they put into the job. That would make no sense. And so the arbitrators took the evidence in front of them, which included the payment applications that Cleveland failed to pay for work actually performed when R.E.M. was not in default, and said, yeah, you need to pay them for the work they performed. It makes perfect sense under the scope of the contract as a whole, which is contractor, you must pay subcontractor for the work they perform.
Okay, if I could just follow up to make sure, and unfortunately now I'm looking at the record part where it's like really tiny at 31.8, but it says, after it says actual direct cost of work satisfactorily performed, then it says subcontractors shall not be entitled to compensation for profit and overhead. So that would be the provision in 31.8 that seems directly contrary to the last section that you were quoting from, which is 29.2.
Well, and I think the way
Do you
to
agree that those two provisions are like directly
on its face, they seem contradictory, but the way to square that is in 31.8 to read that subcontractors not entitled to compensation for profit and overhead on work it hasn't performed yet. And so that's what in 27.1, it says it shall be entitled to profit for work it performed. So if, and this was a Cleveland drafted document. And so, we're bound to it, but it's, that's the way to square those, is that we're entitled to our costs and our profit on work we've actually performed, which makes sense in the context. Otherwise, this would be an incredible contract gotcha to say you're terminated for cause. Oh, sorry, it's wrong. Terminated for convenience. We didn't pay you for the last 6 months, and now we don't even have to pay you profit. We only have to pay you and you have to come in and make some evidentiary showing of what your actual direct costs were. that should not be, that would not lead to a just result, Your Honor.
And so how does all this square with the Rule 48 of the AAA rules?
It squares that because the arbitrators are entitled to do what is equitable and just, as well as what's within the scope of the contract. And so the scope of the contract allows for the arbitrators to award, to compensate R.E.M. for work it's performed, which is exactly what they did.
So did the award provide R.E.M. with any forms of compensation that were specifically prohibited by the subcontracts?
No, not at all. And I'd like to turn it over to our colleague at this point for counsel for surety company.
May it please the court, I'm Kelly Herron and I represent United States Surety Company. So the crux of the argument is Cleveland argues that because the arbitrator stated there was no evidence presented of its actual direct costs, that the arbitrators should not have awarded damages to R.E.M. In the arbitration award, however, the panel also said there was little evidence of job costs presented. I'm going to share my screen for a moment just to point at that language, if that's okay. Can you hear me? Can everyone hear me? Okay. So at paragraph 76,
Page
The
76.
I'm sorry, yes, panel 76 of the award. I'm sorry, paragraph 76 of the award.
And this is record page 17.
This is record page 138.
Thank you. So yours is very tiny, and we don't decide cases based on the technical acumen of counsel. I just want to make
I'm
sure that,
sorry.
no problem. I just want to make sure that could look at a bigger copy, and I'm looking at it now.
Okay, yes. So this is the arbitration award, and this is where the arbitrators pointed at what evidence they did look at to arrive at their damages calculation, and that's at paragraph 76 and 77 of the award. In other words, the arbitrators used evidence that was presented in the proceedings, and they apparently used inferences and estimated what R.E.M's job costs were. The arbitrators had the power to do that. So going back to what North Carolina law says, as far as what it means for an arbitrator to exceed their authority, I'll go back to the Fison and Gillespie case that was referenced by Cleveland's counsel earlier. That case concludes the rule is this: an arbitrator exceeds his authority when he arbitrates claims and matters that are not properly before him. In other words, if the parties agreed to present the issue of damages to the arbitrator, then the arbitrator had the authority to rule on the extent of damages, and that ruling cannot be overturned. In that case, Fison versus Gillespie, the court explained that that's the appropriate question. Did the parties submit the issue to the arbitrators to decide? And clearly in this case, there's no dispute that the parties submitted the issue of the extent of damages to the arbitrators to decide. Therefore, there's no right to appeal. In that case, Fison versus Gillespie, the court held that an arbitrator's award regarding liquidated damages was a matter that had not been submitted to the arbitrator to decide. The plaintiff had made no claim about liquidated damages. Therefore, the court allowed that issue to be vacated because it simply wasn't presented to the arbitrators to decide at all. But our case is different from FCR. there's no dispute that the parties asked the arbitrators to make a decision about damages. That issue is clearly before the court. Therefore, this court may not overturn that. The outcome here is directed by Faison versus Gillespie. I'm going to stop sharing my screen.
If I can just ask you a follow-up question on that.
Sure.
I think I can articulate this correctly. So you're saying in Faison, the issue of liquidated damages had not been submitted to the arbitration panel to decide.
Correct.
That here you said there's no dispute that the parties asked the arbitrator to make a decision about damages.
Correct.
What I understand Mr. Price to be arguing is that, well, the parties asked the arbitrator to make a decision about damages within the scope of the contract. And Mr. Price is arguing that at least Cleveland was saying, what are R.E.M's direct costs, and decide that. But what R.E.M is saying is, well, you said damages, and that includes, I mean, it seems a little bit circular, like it takes us right back to the argument that we just heard from Lex Irwin. Are you following me?
I see. I think it's just simple in my mind, is that the issue is, could the arbitrators make a decision about damages? And was that presented to them? And it was. There's no dispute here that they could decide damages. And so they did not exceed their powers by rendering a decision on the issue of damages. I'll also direct the court to what the argument here is really about: the sufficiency of evidence. Cleveland's complaining there was not sufficient evidence for this damage award, but the court has clearly said in Miller versus Roca, that's 167 North Carolina App 91, a case cited by Cleveland, that an argument about insufficient damages cannot be overturned.
Okay, thank you very much. And you're over your time.
Okay, thank you.
Thank you so much. We'll go back to Mr. Price.
Your Honor. I'm going to start out by answering Judge Zachary's, I think it was her last question to Lex Irwin. Judge Zachary, you said, did the award include any damages not allowed by the contract? I'm trying to paraphrase it. I think that was essentially it. Mr. Irwin said no. And I would say, on its face, the part Cleveland is challenging are damages not allowed by the contract, because what they get in the event default termination is converted to a termination for convenience is actual direct costs. And the panel found that that was the starting point and there was no evidence. And therefore, I would submit that the answer to your question is yes, the entirety of the award, the portion we're challenging. And to be clear, we are challenging what would be paragraph 6 of the judgment at pages 180 through 181 of the record. That incorporates the only part that we're challenging.
Mr. Price?
Yes,
would
Your
you
Honor.
like to respond to counsel's argument, though, that provision 27.1, 27.92, and 31.8 are inconsistent?
Sure.
And that ambiguity must be construed against the drafter, which is Cleveland.
Yes, Your Honor. First of all, I'm going to respond and I'm going to say I'm not sure about the following, but I'm going to say I'm not sure that these issues have been raised in the briefing. And if I'm right, I would think that has, some significance in terms of what can be argued. I'm not going to make that. I've been sitting here trying to word search documents while the other attorneys were talking, because I don't remember it being a significant part, if it was mentioned at all. But I would suggest that to the extent it wasn't, it's inappropriate argument. Number two, it's an interesting argument, but it has nothing to do with what the panel concluded. Whether there was any ambiguity over the overhead component, we don't get there because the starting point the panel said was the actual direct costs. Maybe there's ambiguity as to whether if they put on the actual direct cost evidence, they can then put on the overhead evidence. 31.8 suggests no, and maybe those other provisions suggest yes, but you don't get to that ambiguity because there is no overhead, there is no markup for overhead on zero and actual direct costs. So the answer to the question would be the panel didn't see an ambiguity. The panel didn't focus on an ambiguity. The parties haven't briefed an ambiguity. The panel found that the starting point was the actual direct cost. That's what they need to have evidence of to get out of the starting gate. And the panel says they did not have that. And I would say that, and I get it. I've been on both sides. I've been doing this a while. I get it. And I get why, how the panel thinks it was unfair, but it's equally unfair, I would submit as a policy matter, to simply come in and say, we did not meet our burden, but you should give us money anyway because we won on liability. Contract cases are difficult in that you have to prove liability and damages. And if they prove liability and don't prove damages, it may yield an unfortunate result in their minds, but it's the result dictated by the law. And
Well, I have a question.
yes, Your Honor.
Are you maintaining that the arbitration panel was precluded from estimating the actual direct cost in the event of insufficient evidence of actual direct cost in light of the AAA rules, which were incorporated into the subcontracts?
Well, I hadn't really thought about it quite like that, Your Honor. I would say, in all candor, that had they done that, we might not be sitting here. But what they did, you see, once they say there was no evidence of actual direct costs, which meant something to them because they compared it to job costs, they then go on after that and they start looking for substitutes for actual direct cost, which I think they don't have the right to do. So I'll use a hypothetical example, Your Honor. They say they looked at the pay applications that were unpaid, okay? But I don't know what's in those pay apps. Do they have overhead? Do they have profit? Do they have markup? Are they making a ton of money on the job? Do they represent? So the panel never suggested that they were substitutes for actual direct costs. What the panel suggested was that because it's unfair and we have the right to do this under Article 48, we're going to look elsewhere. These were the unpaid pay apps, close enough. The unpaid pay apps may or may not bear any relationship to actual direct cost. Good contractors, are billing for more than they're spending. If they're a net zero operation, they're not making money. And so I don't think that's what they were trying to do. I think had they thought that, they would have written it. And then in all candor, Your Honor, we probably either wouldn't be sitting here or we'd be having a different discussion. For me, and I know I'm over my time, the starting and ending point is the panel's recognition of what the contract required, actual direct costs. And once they said there's no evidence, that's a knowing deviation from the contract. And the cases all say that they're limited. Their authority is limited. And so, yes, they have an absolute right to award damages, but only those damages contemplated by the contract. And those
I need you to wrap up, Mr. Price.
and those damages are actual direct costs. That's all I was going to say, Your Honor. So we request respectfully that the case be reversed, remanded with instruction to vacate Article Judgment Paragraph 6, which is contained at Record 180, 181. Thank you, Your Honors, for your time.
Thank you for your excellent arguments. The case is submitted. Great afternoon, and we'll be adjourned.
Thank you.
Thank you, Your Honor.
Thank you, Your Honors.